Okay. Hello, my name is Josh Blackman. I am the president of the Harlan Institute, and welcome to the October 2021 term of the virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol versus Bruin, and this is match number 2 of the semifinal round. For the petitioners, we have Shemai DeGeorge and Maeve Durkee from Creekview High School in Texas, and from Mission San Jose in California, we have Andrew Lang and Esther Lau. Petitioners, you have 10 minutes. Begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Shemai DeGeorge, and today I, along with my co-counsel, Maeve Durkee, proudly represent the New York State and Rifle Association, the petitioner in today's case. Would the court benefit from a brief recitation of the facts?
Yes, please.
In the state of New York, obtaining a concealed carry permit is the only way a citizen can carry a firearm outside of their home. After observing a series of robberies within his neighborhood, Robert Nash applied for one so that he could protect himself in case the worst happened. Brand and Koch did the same. Both men's applications were rejected on the basis that wanting to defend themselves was not enough to demonstrate a special need distinguishable from that of the general public under New York Penal Code 400. Neither Nash nor Koch had any criminal history.
The question presented today is whether the New York law, which by definition bars the average law-abiding citizen from carrying a handgun outside of the home, violates the Second Amendment. It does for two reasons. First, because it infringes upon the right to bear arms for self-defense outside of the home that is enshrined within the Constitution. And second, because the law fails to pass any level of scrutiny that the precedent set in D.C. v. Heller allows this court to apply to it.
The Constitution enshrines a generalized right to bear arms for self-defense outside of the home, which the New York law overtly violates. The Second Amendment protects not only the right to keep arms inside the home, but the right to bear arms outside of it. Historically, to bear arms meant to bring them outside of the home, and legal precedent supports that interpretation. 9 dictionaries of and before the time of the Founding Fathers, ranging from publishment in 1604 to 1828, defined to bear to mean to carry or to convey or carry. This is the definition that the framers would have been familiar with. It would make no sense for the framers to protect the right to keep arms within the home and then specifically protect the right to bear or carry them inside the home.
So let me just, if I can just interrupt you, Counselor, and I see Esther just joined in. Thank you. So let me ask you a question, Counselor. Does Heller clearly resolve this case one way or the other?
Could you clarify, Your Honor?
Heller, right, 2008 case. Does that resolve this case? Does that decide what we have to do today?
Yes, Your Honor, because Heller clearly protects the right to protect, for the people to protect to bear arms for self-defense, and self-defense clearly happens outside of the home most frequently.
So where in Heller does it clearly? I mean, you said the word clearly. Clearly means without any doubt. Where in Heller does it clearly say that?
Well, Your Honor, the court in Heller outright stated that the core right of the Second Amendment is to self-defense. Furthermore, the court in Heller—
Self-defense where? Did it say where that right exists?
No, Your Honor, but specifically in keeping it vague and just saying self-defense actually supports our position, which is that the right to bear arms extends outside of the home.
But I get that it supports it, but did Heller actually say it is inside the home, or you're sort of drawing an inference from Heller?
Oh, well, Your Honor, Heller states that you interpreted the right to bear arms to mean that you have the right to keep and bear arms in case of confrontation. It is implicitly within that it protects the right that extends beyond the home, as most confrontations occur outside of the home.
All right, I proceed, Counselor.
Heller holds that at the time of founding, as now, to bear meant to carry, and that in that context means to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action, and in a case of conflict for another person. Additionally, as held in Heller, the primary purpose of the Second Amendment is to allow the people access to the arms for the purpose of self-defense. The need for self-defense is much more
Okay, Counselor, if I may interrupt, I'd like to jump back to a point you were making earlier that somehow a 17th century dictionary has an effect on a case today. Should that be so? Why should we look at dictionaries from 16 whatever?
Well, those dictionaries clearly define what definition the founders were working with. Additionally, the Oxford English Dictionary currently also defines to bear.
And are courts well equipped to get into that sort of historical analysis of what the founders thought? I mean, I can't go talk to George Washington, can I?
Well, it is under historical interpretation. The courts often look to the best understood meaning of the Constitution.
Furthermore, Your Honor, the court in Heller itself delved into the mindset of the founders at the time of that they wrote the
Sorry,
amendment.
Counselor, may I interrupt? So I see, going off of what Justice Carrillo said, and based on your brief, I know you state a lot of history. How do you think that history helps your case that a Second Amendment violation has occurred?
Well, the history defined.
Oh, did you guys freeze?
No, I'm still here.
Same.
Shemai, Maeve, can you hear us? I think you're frozen. I'm sorry. Oh, this happens.
Have the right to bear arms within the Second Amendment. The founders conferred a right to bear outside of the home.
So, counsel, let me ask you a question. And can you hear us okay?
Yes, Your Honor.
Okay, yeah, you broke up just for a second, but I think we got most of what you were saying. So Heller, discusses that you could ban keeping arms in sensitive places. Doesn't that suggest that this right doesn't exist outside the home?
Well, Your Honor, we would contend that it does not. As the court in Heller stated, the right to bear arms protects people, not places. It specifically said that the reason that they're allowed to restrict arms in sensitive places because that is a small, minor, and narrow reach, Your Honor. The law bar in today's case prevents people from carrying arms outside of the home at all, no matter the place, no matter the purpose, no matter the location. Therefore, we are at two completely different things.
Okay, but historically, I mean, even in New York itself, wasn't there limitations on carry in public?
The limitations on carry in public often occurred before incorporation of the Second Amendment to the states, which occurred in 2010 with McDonald v. Chicago. So those laws were not restricted by the Second Amendment.
What does incorporation does it mean change after incorporation? I'm not quite sure I understand your point.
Those laws were not would have been a violation of the Second Amendment, but they were not held up to scrutiny under the Second Amendment.
Okay, thank you. May proceed, Counselor.
That brings us perfectly to our second point, which is that the New York law fails to pass any level of scrutiny that the precedent in Heller allows us to apply to it. In Heller, this court held that legislation that appears on its face to be within a specific constitutional prohibition, such as those of the first 10 amendments, can only be analyzed using strict or intermediate scrutiny. The New York law fails to satisfy both of these. First, because there is no evidence that it supports the respondent's purported state interest in public safety and crime prevention. And second, because it imposes what amounts to a total ban on the constitutionally protected activity of bearing arms for the average person. To expand upon the first reason, the data overwhelmingly supports that there is no correlation between increased concealed carry and an increase in violent crime. According to the Violence Policy Center, America's 18 million concealed carry permit holders only accounted for 801 firearm-related homicides over a 15-year span. Less than 1% of firearm-related homicides.
Well, Counsel, let me just stop you. We're a court. We're a bunch of lawyers. Are we really equipped to be making decisions based on statistics and public policy? Is that really our job?
Well, Your Honor, I would say that it's not your job to wholly base your opinion on statistics. However, Your Honor, we are not using this to definitively prove one way or another. We are using this to prove that there is whether or not there is a relationship between the law at bar today's case and the respondent's purported state interest, which is something that I believe is wholly within your purview.
Okay, you may proceed, Counselor.
Now, not only does the data overwhelmingly support the assertion that licensees do not increase the rates of violent crime, it also suggests that having laws that leave an avenue open to obtain weapons actually reduces it. As recognized in McDonald v. City of Chicago, after a Chicago law essentially instituted a total ban on handguns was passed, the Chicago Police Department statistics revealed that the city's handgun murder rate actually increased, and that Chicago residents now faced one of the highest handgun murder rates in the country.
Well, maybe Chicago and New York are different. Maybe Chicago is poorly run, but New York will have a better approach. I mean, how do we impose like a 50-state solution? Right? Maybe every state should have a different way of resolving these sorts of violence issues.
Well, Your Honor, we agree that that specific firearm restrictions can vary from place to place, as obviously the 50 states are very varied in terms of circumstance. However, Your Honor, it is our position that broad prohibitions on the right to carry outside of the home should not be allowed by this court. And I believe that is something that is general enough, that is not specifically tied to a specific circumstance or state of affairs within a state, that this court can implement it without worrying about that.
Okay, about 30 seconds left, counsel, if you want to wrap up, please.
In conclusion, New York's law violates the Second Amendment because it unconstitutionally restricts the right of the people to bear arms outside of their homes, and because it fails to pass any level of scrutiny that can be applied to it. It is for these reasons that we pray that you rule in favor of the petitioner. Thank you.
Okay, excellent. With 8 seconds to go. Thank you so much, Counselor. Okay, respondents, you can please come on screen. That's Andrew and Esther. Okay, and Shmaya, if you just turn your camera off, please. Thank you so much. All right, you have 15 minutes. Whenever you're ready, you may begin.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court, my name is Esther Lau, and my co-counsel Andrew Liang and I represent the respondents in today's case. Would the court benefit from a brief recitation of the background, or may we begin with our arguments?
Begin with some facts, please. Thank you.
Yes, Your Honor. In a series of concealed license applications in the case of State of New York in September of 2014, the government denied Robert Nash and Brandon Koch permits due to the lack of proper cause. Nash, alarmed by increasing neighborhood crime, completed a gun training course in the hopes of obtaining a concealed carry license. In a similar vein, Koch wanted to increase his self-defense capabilities and utilize his substantial experience in handling arms. Despite clean criminal records, however, they were both denied licenses. With the New York State Rifle and Pistol Association, Nash and Koch filed a lawsuit in the U.S. District Court for the Northern District of New York against Kevin P. Bruin and Richard McNally, two New York State officials who were involved with the denial of their licenses. After having the case dismissed by the district court, they appealed the dismissal to the Second Circuit, who summarily affirmed the decision, arguing that the Second Circuit's previous decision to Kochalski versus County of Westchester was decisive in this case. The question presented in today's case is whether or not the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. New York's licensing scheme is constitutional for three key reasons. First, it does not burden the core protection of the state's amendment's right to bear arms and should thus be analyzed under intermediate scrutiny. Second, the licensing scheme serves New York's interest in furthering public safety and crime prevention. And third, New York's licensing scheme is substantially related to its interests in public safety and crime prevention.
So counsel, what standard of review are you applying there with the substantial relationship? What standard of review is that?
So, yes, Your Honor, we consider that this law should be evaluated under intermediate scrutiny because right now it implicates the core cause, the core purpose of the.
And maybe it's a question for Andrew. Did Heller establish what tier of scrutiny governs Second Amendment cases?
Yes, Your Honor. Heller established that any sort of heightened scrutiny should be applied to Second Amendment cases, so long as it is not rational basis review.
So
I believe
does that mean intermediate? I mean, do we know that from Heller or McDonald?
Well, Heller at least disparaged the use of rational basis review in Second Amendment cases. So heightened scrutiny would most likely be intermediate or strict scrutiny. Now, the issue here is whether we should analyze that under intermediate or strict scrutiny. And right now, we're arguing that we should.
Let me ask you this: if we apply strict scrutiny, do you lose?
We would not lose, Your Honor.
Why?
This statute is still the least restrictive means of achieving our compelling interest in crime prevention and public safety.
But, Counselor, I'll go back to Justice Carrillo's question a moment ago. New York has been an outlier. I mean, how many states permit concealed carry? I mean, I mentioned a number, but are there some states that permit concealed carry?
Well, there most likely would be.
And are those cities just destroyed by runaway violence? I mean, isn't there some other way that New York can protect public safety while recognizing this right outside the home?
Well, we do believe that, Your Honor, this is the least restrictive mean of achieving.
Is this the most? There's no other way that New York could prohibit gun violence.
Well, the only other way that we can think of right now is if we had everyone demonstrate that they were capable of, possessing a handgun. But that would be inefficient because if or at least if we had the government go and determine if everyone was capable of handling a
Well,
firearm.
so let me go back to Esther for a minute. What if the government said anyone who passes a competency test, you go to a range, you prove you can shoot, you can prove you have, good accuracy, you don't have a criminal background. If you just pass a competency test, you get a gun. Esther, why wouldn't that be why would that be a less restrictive means in the current New York policy?
Right, because right now, the state of New York's purpose in having this law is to prevent public crime and
I get
also
that, but you said this is the least restrictive means. That's what I'm sort of focusing on now, right? Why couldn't New York just say, as long as you pass a competency test, you prove you're accurate with your gun, you're a good shot, you're gonna use it safely? Why would that not be a lesser restrictive means than what New York has now?
Your Honor, I believe that would not be a less restrictive means because that would make sure, because right now the New York law requires that people who have guns and arms need to qualify under this, but because the hypothetical situation we're discussing requires people to pass competency tests, that might not be the most accessible, and I believe
but now there's no way of doing it. At least under the hypothetical I gave, it's possible that the petitioners here can get a gun if they're good shots. Under the regime in New York now, it's a flat no, because New York said you don't have good enough cause. Why? Again, maybe you lose under strict scrutiny, but if your standard is you are the least restrictive means, it seems that there are a lot of other ways you could accomplish your goal.
Well, Your Honor, we wouldn't say that it is a complete flat no. It's just, I mean, if you want to compare it to like a total ban, this would clearly not be a total ban. Like compared to the statute in Heller, right? Heller mandated that every firearm that you possess, even in a home, be unloaded. So you pretty much lose the right to self-defense in that case, because it would take time to load a firearm and defend yourself in a home. And Heller at least stated that this right to bear arms for self-defense was most acute in the home, which meant that it was definitely within the core.
Well, let's go back to Heller for a minute, right? We have this language in Heller, I mentioned it a minute ago to your friends, that the right to bear arms, that the Second Amendment can be restricted in sensitive places. For example, like maybe a school or a government office or courthouse, right? But if the court says that there are some sensitive places, doesn't that fact imply that there's some non-sensitive places, that there are some places that are not so sensitive?
Well, yeah, and that's what the New York statute.
No, but New York's everywhere. New York says you can't carry anywhere. It doesn't distinguish between sensitive and non-sensitive places.
Well,
the entire state is a sensitive place, basically.
Well, Your Honor, we do distinguish between licenses. And generally, an individual can obtain a license to carry a firearm concealed. And it's just a matter of how many restrictions.
But that's so good. But what exactly is this good cause standard, maybe for Esther? What is the good cause standard? What does good cause even mean here?
Yes, Your Honor. So good cause in this situation means that there is imminent harm, and that qualifies as a reason as to why they would need arms. So for example, let's say we have a domestic violence victim who has been experiencing constant threats from their abuser and has already been experiencing harm in the past. And we would say that would be an example.
All right. Well, I mean, that's an example, but what happens if while she's waiting for the police to approve her permit, she's killed? I mean, if she faces some harm, increasing, if she files with paperwork and you don't face enough of a threat, wait a couple more weeks, see if he beats you up some more. I mean, is that the standard? We have to wait for it to be really a lot of domestic violence, not just a little domestic violence?
Sorry, could you repeat the question?
Sure. Let's say that the amount of domestic violence women's experience is just a little bit. It's not a lot. Does she have to wait to get really beat up before she gets a gun permit?
Well, no, Your Honor. We would believe that as long as there is imminent harm, then.
Yeah, but what if it's not quite imminent? What if just she's afraid of it, but he hasn't quite threatened her yet? I mean, the idea of this standard, this good cause standard, means you have some officials saying, "Well, let me think about how much in danger you really are," right? Doesn't that leave people at risk for vulnerable people at risk?
Well, Your Honor, we believe that at certain point there has to be a line that is drawn. So there's always going to be people on either side of the line. And we believe that this, like, people who are going to be at risk is going to happen in any scenario. Even if, say, let's take the hypothetical case we discussed earlier, even if we allowed people to take a competency test, that would take time as well. So in either situation, there's really going to be people who are going to be at risk, given which side of the line they're on.
Okay.
Counselor, I'd like to hear, I apologize.
Go ahead, Justice Carrillo.
I'd like to hear why, more on your first point, why this does not burden for Second Amendment protections. Perhaps Mr. Leong can answer that.
Yes, Justice Carrillo. So essentially what we're saying is that, first of all, licenses in New York are distinguished. So you can obtain a license to carry firearms in the home, and you can also obtain licenses to carry firearms outside the home, provided that you show good cause. And as we would establish, the core protections of the Second Amendment only apply to the Second Amendment for self-defense in the home only. And
where are you getting that, Counselor? Where in the Second Amendment does it say that?
Well, we're basing this off of a historical analysis, as Heller would counsel. Heller does suggest that we should start from a historical analysis before we determine whether a regulation burdens the core protection of the Second Amendment. So first off, we do believe that history has a backing for the regulation of concealed firearms, dating back to when King Edward I ascended to the throne. Now, Edward I and II all had some sort of policy prohibiting the carrying of firearms without their express permission. So you had to obtain a license from the king in order to possess a firearm. In the Statute of Northampton, Edward III assigned the justices, mayors, sheriffs, and bailiffs to enforce the provision of the statute by issuing these licenses under the king's authority.
Am I incorrect in believing that all the old English statutes were discriminatory in nature towards Catholics, and likewise all the carry restrictions in the United States were discriminatory towards African Americans? Am I incorrect in my understanding of history?
Well, Justice Carrillo, even if we do accept that that is true, we can look towards the English Bill of Rights, which established the right for Protestants to also bear arms as permitted by law, and Blackstone's commentaries recognize that. But the main thing is that we also this phrase "as permitted by law" actually means what it says. So Granville Sharp explained how this phrase honors Henry VIII's regulation of weapons that were concealable or dangerous in nature, and we do explain that in our brief.
You may proceed, Counselor.
Continuing on. So after the founding of the United States of America, the founding fathers in several state constitutions noted that the right to keep and bear arms for self-defense had two main goals. The first was to defend one's property and home, and the second was to defend the state in times of conflict. The founding fathers feared that the universal militia would be disarmed by the federal government, and it was the primary reason for including the Second Amendment in the Bill of Rights. Even military officials, however, have argued that the
Counsel, how is a militia supposed to function if they can't take their weapon outside their home?
Well, no, we're saying that individuals in the militia should keep their should be able to take care of their firearms in the home. You have to be familiar with the firearm to shoot it, of course. And if I were to suddenly go out and with the Smith and Wesson, right, and I didn't know how to shoot it, that would be a major. And I was in the militia, then that would present a major danger to not only to my fellow soldiers, but to the general public as well. So even military officials have argued that the management and possession of guns was much more suitable at home. And the licensing scheme only relates to concealed carry licenses, so it does not implicate the core components of the Second Amendment, and thus should be analyzed under intermediate scrutiny.
And second, we argue that New York's licensing scheme survives intermediate scrutiny, which only requires a regulation to be substantially related to an important government interest. New York has an important, even compelling government interest in crime prevention and ensuring the safety of the public. This court has previously recognized that states inherently have the power to guarantee the well-being of the people. Furthermore, the licensing scheme is substantially related to New York's interest in preventing crime and ensuring public safety, because currently in the state of New York, excluding New York City, 1 out of 5 violent crimes involved a firearm. But if the petitioners argue that this statistic is too widely cast, let's turn to those of Rensselaer County, where Nash and Koch are both from. In 2020, 33% of violent crimes in that county were firearm related, which is a stark contrast to the decreasing rate of crimes and the percentage of firearm related crimes from 2010 to 2019. But this percent change in firearm crimes from 2019 to 2020 was 52.8%. One plausible cause of the spike is the pandemic, which is another reason as to why this licensing scheme passes intermediate scrutiny, furthering public safety in a time of turmoil.
Right,
But let's compare.
You have 10 seconds left if you want to just wrap up.
Yes, Your Honor. The petitioner's arguments that the Penal Code violates the Second Amendment are insufficient because they directly contradict with Heller and the state court rulings, as courts have held that regulations against concealed carry firearms were constitutional. So we ask that the judgment of the Court of Appeals be affirmed. Thank you, Your Honor.
Okay, excellent. Thank you so much. All right, we now have 5 minutes of rebuttal time for petitioners. Whenever you're ready, begin. And if Esther can just turn your camera off, please. Thank you.
Mr. Chief Justice, and may it please the court. In our rebuttal today, we will be refuting 2 points that respondents made in their argument. First, their claim that the Second Amendment confers a core right to keep arms within the home and a peripheral, less protected right to bear arms outside of the home. And second, that their claim that the law at bar today should be analyzed under intermediate scrutiny.
Your Honor, respondents claim that the Second Amendment confers a core right to keep arms within the home and a peripheral, less protected right to keep and bear arms outside the home. In asserting that the use of arms within the home is the sole core of the amendment, the respondent turns to Heller, claiming that's what it held. However, what the respondent failed to mention is that there is not a single sentence in the majority opinion of Heller that states that keeping arms within the home is a core right and that bearing them outside of it is a less protected one. What Justice Scalia actually wrote in his majority opinion is that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. He also stated that the actual core purpose of the Second Amendment was self-defense. As the need to defend oneself most commonly arises outside the home, and since most violent confrontations also take place outside of the home, this implicitly contradicts and therefore refutes the respondent's interpretation.
Respondents also claimed that the New York law should be analyzed under intermediate scrutiny, as it is their position that it does not burden a core right within the Second Amendment. However, as we just illustrated, the court in Heller defined the core right to be the right to keep and bear arms for the purposes of self-defense, which implicitly includes the right to carry outside of the home. Therefore, because it takes away the ability for the average person to carry handguns outside of the home, the law does burden a core right, and thus under respondents' own rationale, should be analyzed under strict scrutiny.
Well, counsel, let me ask you a question, right? Let's just say we agree with you that heightened scrutiny applies. And let's say maybe we agree that's more like intermediate. Why wouldn't the good cause standard satisfy strict scrutiny?
Do you mean why it wouldn't satisfy strict?
I'm sorry, you're right, my mistake. Why wouldn't the good cause standard satisfy intermediate scrutiny?
Well, Your Honor, simply put, it wouldn't satisfy intermediate scrutiny because it is not narrowly tailored to respondents' purported state interests, Your Honor. Their state interest that respondent put forward was public safety and crime prevention, Your Honor. If New York sought to reduce crime or protect the public at large, they could simply restrict the arms on the specific.
That sounds like more of a strict scrutiny argument, though. I mean, you say narrow tailoring. Usually for intermediate scrutiny, you don't need narrow tailoring. It's got to be substantially related, but it doesn't have to be perfect. I mean, why isn't a good cause standard a reasonable, not rational, but a reasonable way of accomplishing a reduction in gun violence?
Well, Your Honor, one of the reasons that we would say that it's not a rational way to do that is because of the specific discretionary standard that it imposes, Your Honor. It is not uniform. What kinds of people are allowed to possess weapons is going to vary from person to person, depending on what officer there is. Therefore, there is not a way to say that this definitively reduces crime. Furthermore, the statistics do not show a causational relationship between concealed carry permits and an increase in gun violence. Therefore, we cannot say for certain that this is substantially related to respondents' purported state interests.
Okay, you may proceed, Counselor.
Now, since the law does burden the core right, and thus under respondents' own rationale should be analyzed under strict scrutiny, the law fails as it is not the least restrictive means of furthering the government's purported state interest in public safety and crime prevention. Instead of specifically banning the small minority of people most likely to abuse handguns, like felons and the mentally ill, from carrying them, or applying specific time, place, and manner restrictions, the law bans the average law-abiding citizen of average moral character from carrying weapons instead of, and therefore should not be considered the least restrictive means of advancing the state interest. It is for these reasons we pray that you rule in favor of petitioners. Thank you.
All right, excellent. Thank you so much. I will stop the clock. All right, if the other team come back in camera, please. This was excellent. I have to tell you, when you're getting these sort of hard questions, we're hitting you so hard, it's a signal that we expect you to be able to answer them, and you did. These are the sorts of questions you would get in a law school competition with this sort of rapid fire. You said this, but what about this? What about this? What we're trying to do is push you, see how far you go before you deviate from the position in your brief. And that's one of the hardest things lawyers have to do, because the judges up there know what you put in your brief. We know what your positions are, and we're trying to make you feel uncomfortable. Say, well, if you do this, what about this? And these questions about domestic violence and beating people up, my goodness, these are hard questions. I don't know the answers, but you all had composure. You all were collective. You were maintained. You didn't freak out. You kept your pace. You kept your diction. You didn't lose your cool. And throughout all these hard questions, whenever we asked you something, you pivoted back, right? You said, well, let me go back to my material. Then you started going where you wanted to go, right? It's going to be the case when you're an attorney, and I think maybe you will be one day, that the law is not on your side, right? The law is often not going to be on your side. You can't fix that. And in those sorts of cases, you have to sort of rely on perhaps the facts and maybe why the facts are different. And there's some cases where the facts are not on your side, then you have to sort of fall back on the law. And then there are cases where the facts are not on your side, and the laws are not on your side, then you just sort of pound the table, as they say, right? But you have to sort of finesse it and try to come up with some creative way to position it. The Second Amendment issue has been litigated forever. We know what the issues are, but the sorts of questions we're asking you really push your comfort level where you're willing to go with this. And I thought you both teams did a really strong job. I know it's not easy doing this over Zoom. I see that Esther and Andrew are in different locations. We start to sort of naturally pivot back from one to the next. I think it does create a level of complexity. But look, a lot of lawyers today are doing their arguments on Zoom now, even after, God willing, this pandemic's over. Hopefully soon. We're still dealing with Zoom. And I'm just very proud of you all. And I've been doing this now for about 10 years, and every year it seems to get stronger and stronger. I have to keep making my questions harder and harder and being more and more abrasive to try and see if I can push you. But thank you so much. Ashley and Reed, these are my students at my law school, some of our top students, and their feedback I think should be taken seriously. But what are your thoughts?
I think everyone did a great job. You were all very impressive. It's amazing just seeing people as young as you perform at the level you're performing. Professor Blackman asked some very tough questions that I'm not sure I could answer.
I can't.
So I mean, they're rough. They're rough, and I thought you all did a very good job. Good for the most part. Good tone and good pace, and good knowledge of the law. I was very impressed.
I agree. I was really impressed. I don't think I could have done this in high school. I definitely don't think I could have answered some of Professor Blackman's questions. They were hard. It's a tough subject, but y'all did really well. I think you kept composure, and you just answered it to the best of your ability. And I think y'all did really good.
Thank you
Yeah,
so
if
much.
we didn't think you could handle this, we wouldn't give it to you. Trust me. If I see a team is struggling, I pull back. I only sort of put the gas when I see you can handle it. So it's a signal that I trust you, right? Trust me. If this was a disaster, I'm like, okay, let me pull back a bit, but I went full speed. Do you have any questions for us? I always like to give the students a chance to ask us questions. We put so much work into grilling you. Now you can grill us for a little bit. Please, whatever you want.
Yeah, this is a general question to all three of you. But do you have any advice for students who are pretty intent on pursuing law, particularly like public interest law, maybe?
Sure. Well, I'm a professor, and these are two current law students. I'll give you my perspective, and maybe they can give you theirs. There's no single path, right? We can all study different things. We can all have different majors. The advice I would give you is learn how to write. Writing is a skill that will protect you for the rest of your life. If you're a good writer, you can do anything. Learn how to write. If your college has a moot court program, try it. If your college has a mock trial program, try it. You may find you don't like it. Maybe you find you like something else much better. There's no, you're not locking yourself into something when you're 17 years old. That's not when I was 17, I know what the hell I wanted to do. But I appreciate that. Public interest law is very valuable. If you don't know, public interest law is like working for nonprofits or government organizations or trying to help people, however that help is defined. One perhaps non-obvious advice that may not apply is if you have a lot of student loan debt, it's harder to do public interest law because you have to pay off your bills. So if you're really committed to public service and you're choosing colleges, or you're choosing law schools, pick something with scholarship money, and maybe not so the top rank, maybe you get a full scholarship from Yale Law School. God bless you, but not everyone does that. Right. No, I'm serious. So if you're really committed to public interest law, not having student debt liberates you a bit, because when you graduate and read and actually are graduating fairly soon, I had over $100,000 of student debt. Took me a decade, 10 years to pay off. I paid off when I was about 30, 34, 35. Took me a decade. And this was, working as a law professor, not the highest salary, but, I was paying it off. And for some people, if you try and look at public interest law, which does not pay well, it's meaningful work. It's very meaningful work, but the salaries just are not there. You say, shoot, I got to pay off a 6-figure debt of loan. I go work for a law firm for a couple of years. Then you sort of get what they call golden handcuffs. You ever hear the expression? You sort of just chained to the desk. But having less debt allows you the flexibility to say, screw it, I'm going to go volunteer for, in the valley somewhere and help legal aid for people who can't speak English. Reach from the valley. I was just thinking of him, right? But there's a lot of work that can be done that way. Oh, this is why the Rio Grande Valley in Texas, not the you guys from California, not the valley in California is very different than the valley in Texas. Does that answer your question, Esther?
Yeah, that does. Thank you.
And if you have any questions, you guys can email us later. You have information. Maeve, Shemai, you guys have any questions for us?
I was wondering, like, what colleges or types of colleges tend to have the best moot court programs?
Reed and Ashley.
I can answer that. Texas Tech has an excellent program. Our law school has a very good moot court program. One of the best. South Texas is really good. Texas Tech is really good. St. Mary's is really good. University of Georgia is very good. George Washington is very good. And that's Alabama has a decent program, more so for mock trial, but I believe they're a very good moot court program. UC Hastings, there's a bunch.
And undergrad, what about undergrad schools? Any?
Oh, undergrad. I'm so sorry. I couldn't tell you undergrad. I was listing off law schools. So
Yeah, I'm not exactly sure about undergrad, but everything Reed said sounds good for law school.
One thing you can Google is if a school is a pre-law society. Most schools do, and just see, have their mock trial teams won a championship in the last decade? That you can just Google that. But it's something to think about. Most colleges have pre-law, have mock trial, and coaching really does matter. And having a good coach can really, and I'm sure both of you are well coached. I know you're a teacher in Texas. I don't know I don't know Cheryl quite as well, but a good coach really does make a difference, and it changes how you approach the entire process.
What majors did you guys choose when you were entering into college?
Sure, I was computer science. Actually, what did you study?
I was a business major.
Business and
I studied political science.
So all over the place. There's no one major that you need. I teach law students every year. They major in everything, philosophy, medicine, whatever you want. Law is a very unique career because there's so many different ways to apply it. There's not just one single path. It's fun though. Yeah, when you're in college, take some classes in political science, take a constitutional law class, take a criminal procedure class, civil liberties class. You'll enjoy it. I think you'll have fun. Anything else you want to ask us? Cheryl, anything that you'd like to ask? Thank you for coaching your kids.
Oh, no, I have no questions. It was, I mean, watching the students, I couldn't do this in high school at all. And in fact, you're on par with listening to the Supreme Court itself and their own arguments. The poise you all had was so impressive. So don't even worry about law school and undergrad. You guys are already there. You just need to, be curious about the world and enjoy it. And you'll go so far. I'm so impressed. So thank you for letting me watch. It was so wonderful.
Of course. Yeah, and so some of the questions I was asking were from the Supreme Court. So I was basically stealing the questions the actual justices asked. You didn't know that.
I thought you were more like Scalia.
Me? Scalia? No.
Yes, you are hard.
Never. These guys are laughing. Well, that's a compliment. All right. Anything else we can help with you? All right. Well, I'm going to end this session. Thank you so much. The students can please sign off, and I'll talk to the judges for a bit, and we'll have the scores posted by about Monday or so. Thank you so much. Take care. Good luck to you all. Let me stop the recording.